Thank you so much for joining us today for this discussion on international protection in the context of disasters and climate change in Africa, focused specifically on the declaration that the Refugee Law Initiative from the School of Advanced Study at the University of London has put together with a group of experts last year and published earlier this autumn. I'm Jocelyn Perry. I'm the Climate Displacement Program Manager and Senior Advocate with Refugees International, and I am joined here today by Professor David Cantor, who is the founder and director of the Refugee Law Initiative at the School of Advanced Study, University of London, among many other accolades and academic expertise in the field of climate change, environment, and migration and displacement. So how we'll run today's session is David will give an overview for about 20 minutes of the declaration and its applicability in African contexts, and then we will open up to questions from those of you in attendance. So in order to answer your questions, if you can drop them in the chat as you think of them, even while David is speaking, then we'll be able to get to as many of those as possible during the latter half of the session today. So thank you again for being here, and I will turn it over to you, David.
Well, many thanks indeed, Jocelyn, and to Refugees International for supporting this particular workshop, and it's a real pleasure to be speaking on a panel with you again. So on behalf of the Refugee Law Initiative at the University of London, I'd just like to thank also Nick Maple for all the background work in putting this together, and to thank all of you as participants for being interested in this increasingly important area around how we provide international protection, whether that's through refugee status or human rights law, in the context of disasters and climate change. So the focus of today, as Jocelyn mentioned, is to present and discuss the recent RLI declaration on international protection that concerned this particular topic. In other words, international protection in the context of disasters and climate change. But I'd particularly like us to think through in the questions section, as much as anything, how the points raised in the declaration might be particularly applicable in the African context, as I understand that it's through those Africa-based networks that much of the dissemination for this event's taken place. I trust that everyone's seen a copy of the declaration and background paper, which are both freely available through the RLI website and have been published or freely available as well in the International Journal of Refugee Law. For those of you who haven't yet seen them, I believe that links to those papers will shortly be posted in the sidebar in a moment. So why are we speaking about disasters, climate change, and international protection? It's well known that disasters linked to natural hazards can be a push factor for displacement. For instance, sudden onset disasters linked to natural hazards, such as storms, flooding, volcanic eruptions, and wildfires, are estimated to have triggered over 300 million incidents of internal displacement between 2009 and 2022 worldwide. Meanwhile, slow onset disasters, and here we're talking about things like drought and desertification, also add significantly to human mobility trends. Both sudden onset disasters and slow onset disasters are, of course, phenomena that are well known on the African context, which is particularly exposed to some of these hazards, including those that are weather-related. Globally, though, unchecked climate change is likely only to exacerbate these disaster-related tendencies and potentially the mobility and displacement-related trends associated with them. In tandem, the risks of harm that people face as a result of disasters and climate change in their home countries are also increasingly raised as issues in claims for asylum or international protection. But amongst lawyers, decision makers, and policymakers, I think it's fair to say that considerable confusion still persists as to whether persons facing these kinds of risks are eligible for international protection, whether this is as refugees or under the non-refoulement provisions of human rights law. Next slide, please. Against this backdrop, the new RLI Declaration seeks to offer accessible and practical interpretative guidance on this point. It draws on the input of a wide range of experts within the extensive research affiliates networks that are hosted here at the Refugee Law Initiative. And we draw particularly on those who specialise directly on displacement in the context of disasters and climate change. And you can see on the screen the names of those people involved with the drafting of both the declaration and the background paper. Next slide, please. In today's session, I'm going to briefly outline some of the key points from the declaration as they relate to three conceptual and legal questions that you can see on the screen. We'll think particularly about how they may apply in the African context during the discussion period that we have afterwards. And I hope that there should be plenty of time for debate and exchange on the themes addressed by the declaration after the 20 or so minutes that I'll be presenting to you now. Next slide, please. So if we start with the conceptual approach to these issues, I'd say that there are three main conceptual challenges for practitioners, in other words, people who are making decisions on refugee claims or litigating refugee claims as lawyers or as members of NGOs or so on. So the first of these three conceptual challenges relates to how we can understand disasters and climate change within the specific context of a claim for asylum. This is fundamentally a conceptual challenge rather than a legal one. But without a proper understanding of this issue, it's almost impossible to deal appropriately with claims in this area. In other words, claims set against the backdrop of disasters and climate change in the country of origin. In this regard, it's important to recall that refugee status determination is concerned primarily with the risk of harm to a claimant on return to their own country. As such, we need to go beyond labels like climate change refugees, and instead we need to look empirically at the specific kinds of risks of harm that disaster contexts can produce for applicants for asylum. Next slide, please. The RLI Declaration treats this issue as primarily a factual matter. It identifies 5 common scenarios in which a risk of harm may arise in disaster contexts. The key point is that such risks can arise not only from the manifestation of a natural hazard, like a storm or an earthquake. Rather, as you can see from the scenarios described in points 1 to 4 on the screen, there are various other potential sources of harm in disaster contexts that need also to be carefully considered. And a strong element of human agency is apparent in all of them. Moreover, even for scenario 5, where the risk of harm derives from the manifestation of a hazard, such as a storm or an earthquake, it's important to recognize that the risk of harm in this context, in this scenario, is also crucially shaped by societal factors. So human factors influence the extent to which people are actually exposed to the hazard, how vulnerable they are to its effects, and whether or not they've got the capacity to manage those dangers. For example, the fact that in 2010, a 7.0 magnitude earthquake in Haiti killed over 200,000 people, whilst an earthquake 500 times more powerful in Chile in the same year killed fewer than 600, is due primarily to human factors relating to the different levels of disaster preparedness and response in those particular countries. So another key point here is that all of the risks of harm in these 5 factual scenarios that we've identified, including scenario 5, are all, to a greater or lesser degree, directly influenced by human factors. In other words, the risk of harm doesn't just arise from natural hazards, but they're shaped very closely by the way in which societies prepare for those hazards, by the way in which the risks of those hazards are managed, and so on. And this has really important implications for applying the rules of international protection as found in refugee law and human rights law. Next slide, please. So the second conceptual challenge is evident in the tendency amongst refugee judges, decision makers, and lawyers to treat disaster-related risks of harm as if they were distinct, i.e. separate from risks of harm that come from other sources, such as conflict or political violence. But the risks deriving from these other sources of harm interact with and can even heighten the risks deriving specifically from the disaster context. For example, you can think about ways in which somebody who is exposed to a risk of harm due to conflict in their country moves to another area, but because they're moving to an area which is an IDP camp and very poor, perhaps that area is very much exposed to disaster-related risks, and therefore the risks of the conflict, risk of violence, intersects with the risks posed by natural hazards or the risk of a disaster. And this, I think, emphasizes the importance for international protection of taking a cumulative approach in these sorts of cases where intersecting risks of harm can result from various sources. And I think that this is a really crucial point, particularly in the African context, where not only have you countries in a number of regions of Africa where there are distinct risks deriving from persecution, from violence related to armed conflict and so on, but also in those same countries, you're dealing with societies that are very much exposed to sudden onset hazards, whether those be things such as flooding or slow onset hazards such as desertification and so on. So a third conceptual challenge which we face in these types of cases is to understand how climate change enters into this analysis. So thus far, we've been talking about hazards and the way that they can cause disasters. But what about climate change? Well, in essence, over longer time periods, climate change acts, if you like, in the background to mold the risks posed by more proximate sources of harm. In other words, hazards like weather-related storms and so on. In this way, climate change can be seen as acting as potentially a threat multiplier, making climate-related hazards such as storms or flooding more frequent, intense, or more unpredictable over time. We also know that the effects of climate change can reduce the capacities of a society to respond to the risks posed by these kinds of hazards, and it does that by weakening the institutions and infrastructure necessary for a state to protect its people. For the purposes of international protection, then, climate change can be treated as a factor that over relatively long periods of time shapes the likelihood of a disaster occurring and also shapes its degree of severity. And I think that this is the right way to look at it rather than as a standalone source of harm in its own right. So with a firmer understanding of how disasters and climate change generate risks of harm to people, we can turn now to see how the law applies to these kinds of factual situations. And in presenting here, I'm going to assume that everyone is familiar with the basic definitions and rules of refugee law. As such, I'm going to focus instead on how those definitions and rules apply in the context of disasters and climate change. Next slide, please. So looking at the legal approach at the outset, it's really important to recognize that alongside refugee and human rights law, there exists a wide range of other national and international legal and policy frameworks which are potentially relevant to the admission and stay of people who are fleeing from a country affected by a disaster. Indeed, the international protection regime will often not be the principal framework for resolving these legal issues. Rather, we've seen in a number of contexts that broader migration-based frameworks at the regional and national levels are likely to be highly relevant. One implication of this is that keeping existing lawful migration routes and options open for people from disaster-affected countries is likely to be as important, if not more so, than thinking about how international protection law applies to people leaving those countries. When we talk about these broader migration frameworks, we're talking about things like study categories, we're talking about things like economic mobility and so on. But there are also a range of provisions that states use in order to deal specifically with the migration-related aspects of disasters. And I have a paper in the Chicago Journal of International Law, which describes very, very broadly all of the ways in which that's done across the continent of the Americas. And you might want to think about how that then applies in the context of African national migration law as well. And Tamara Wood, a colleague at the RLI and one of the drafters of this declaration, has published some work on that as well. Nonetheless, in practice, international protection frameworks in refugee law and human rights law may still come into play as a way of addressing the protection-related aspects of mobility in the context of disasters and climate change. This is clearly most likely to be the case where a person outside their country for disaster-related reasons is unable to avail themselves of one of the other broader migration-based options in this wider toolbox, and where the disaster-related risks of harm in the country of origin are obviously sufficiently serious. So how then does international protection law apply? Well, in determining disaster-related cases under international protection law, the Declaration identifies two key overarching principles. The first of these is that each claim must be assessed on its own facts. In other words, the existence of a disaster doesn't mean that there's always going to be a need for international protection, but also it doesn't mean that international protection needs can never arise in disaster contexts, as some of the early refugee law judgments have wrongly suggested. Instead, what's needed here is for decision makers to undertake a careful review of the facts of the situation faced in order to identify the actual risks of harm and to evaluate whether, cumulatively, they engage the international protection rules. In other words, you're not automatically a refugee by the fact of fleeing from a disaster context, but equally, the fact that you are fleeing from a disaster context doesn't mean that you're not a refugee or you can't be a refugee. One needs to look at the facts very carefully, evaluate those risks, and see whether or not they fit within the box of refugee law. The second point related to this is that no new or special rules apply to determining disaster-related cases for international protection. The ordinary legal principles and evidentiary rules of refugee status determination apply unchanged. There's no need to import definitions from disaster response law, which, for example, defines what is a disaster, or to determine whether a situation, let's say in a country such as Mozambique, is in fact a disaster under that particular definition. What you're applying instead is the refugee definition, and there's no need to apply definitions or rules from elsewhere. The only change that you might see is that some of the sources of country of origin evidence relating to the risks that arise in disaster contexts may be new and somewhat unfamiliar to decision makers. Most of us who work in the refugee law field are used to relying on sources of evidence such as the US State Department reports or Amnesty International reports that deal, by and large, with questions of violence, persecution, and so on. But I think we're going to have to get more used to dealing with broader sources of evidence that deal with the risk of disasters and the way in which those risks are managed by countries, as well, of course, as the impact of climate change in relation to those sorts of risks. So we might be talking here, for example, about evidence that comes from the disaster field. That could be things like the reports produced by National Red Cross societies or the International Federation of the Red Cross, or NGOs that work on disasters as opposed to issues of violence. But no new rules apply. We just need to be considering a broader range of evidence, which we may not be quite so familiar with. Well, if these are the two basic principles that underpin the whole approach, let's see now how those principles play out in relation to the definition of the refugee contained in Article 1A2 of the Refugee Convention. Next slide, please. As we said, one of the most important things to remember here is that when we're dealing with people who are fleeing from contexts defined by disasters and climate change, there's no need to try and use confusing and non-legal terms such as climate refugees. We don't need to determine whether they're disaster refugees, climate refugees, disaster displaced persons. All we need to keep doing is continuing to apply the standard Article 1A2 refugee definition to the facts. But how does this play out in relation to disaster-related cases? Let's start with the Article 1A2 element of being persecuted. All of you will be familiar that in order to be a refugee under Article 1A2, a claimant has to be outside their country owing to a well-founded fear of being persecuted on one of the 5 convention grounds and be unwilling or unable to avail themselves of the protection of their country. So what does being persecuted mean in this context? Well, it's evident that the intentional infliction of the kinds of harms identified in scenarios 1 to 4 of the Declaration can easily qualify as persecution, so long as the harm is serious enough. We're talking here about scenarios, for example, where a government might withhold essential food aid or withhold disaster relief following a very serious disaster and therefore, in a sense, persecute people through those kinds of harms, or where a government might pursue a person for speaking out on climate issues, detaining them or mistreating them. All of those scenarios 1 to 4 involve intentional infliction of harm, and clearly they can qualify easily as persecution. By contrast, though, in scenario 5, which deals with where people are exposed to a natural hazard, it's difficult to say that a natural hazard, a storm, flooding, drought, is in itself persecutory. Nonetheless, it's important to bear in mind that the fact that a person is exposed and vulnerable to that hazard might well be due to discriminatory practices by the state or society. For example, it may very well be that in a particular African country, people from one minority ethnic group are forced to live in a particularly danger-exposed area, an area that's particularly exposed to sudden flash flooding or to very serious storms without any real opportunity to escape that, and that they are there because they are intentionally discriminated against by either the state or the society in question. In those sorts of cases, then the situation of harm posed by the hazard might potentially be characterized as persecutory if the harm is serious enough, because the fact that the person is exposed to the harm reflects intentional discrimination on the part of human action. Conversely, though, this probably wouldn't be the case where exposure and vulnerability to a hazard were the result of other factors, whether those are generalized poverty or simply the fact that you happen to live in a very low-lying area. Moreover, it's worth remembering that in the disaster context, as in other contexts of claims, the severity threshold for persecution should always be treated cumulatively. For instance, the serious everyday forms of discriminatory ill treatment faced by a member of a marginalized minority group must be considered cumulatively along with their exposure or vulnerability to the effects of natural hazards where that's due to such discrimination. In other words, discrimination can play out in a range of ways. It may mean you're discriminated against, you can't get a job, you're discriminated against that you're attacked in the street, but it might also be you're discriminated against and forced to live in a very danger-prone area. And those dangers have to be looked at cumulatively when assessing whether that situation of harm, with all of those different factors reflecting discrimination, amounts to persecution. Moving on from persecution to the reasons for the persecution, in disaster settings, it's evident that the human element of the harms in scenarios 1 to 5 will often be for reasons recognised by the Convention. For example, holding back disaster relief from political opponents or from despised ethnic minorities is likely to engage the established Convention grounds of perceived political opinion or race in the case of ethnic minorities. Equally, though, a government's disaster response and climate change policy are often highly political issues that relate directly to the functioning of the state. As such, activism or criticism around these issues may very well engage the Convention ground of political opinion or be perceived by persecutors in those terms. A more complex issue in this area of law, though, is how to evaluate well-founded fear. In other words, does the person have a well-founded fear of being persecuted due to one of those 5 grounds? So it's complex to evaluate well-founded fear in cases where the purported harm lies further into the future. And this issue is, for example, raised by scenario 5 in cases where the disaster that the person fears are slow onset, and this might include those linked to the effects of climate change. Now, some courts have suggested that these kind of slow onset harms or harms further into the future can show a well-founded fear only where they are imminent in time. But the RLI Declaration takes a different view and argues that there isn't, in fact, any legal requirement in refugee law that these kinds of risks have to be temporally imminent in order for them to be well-founded. Rather, we suggest that in these sorts of cases, time operates more like a sliding scale as to the strength of evidence that's required in order to show that the fear is indeed well-founded. So the further into the future that the feared scenario lies, the more compelling the evidence will need to be of the reasonable likelihood of its occurrence, and of course, the absence of potential mitigating factors. Nonetheless, given that many natural hazards are either recurrent, seasonal, or worsening in the context of climate change, we believe that decision makers should be hesitant to find that the fear of a hazard recurring is not well-founded, where the hazard is one that's seasonal, recurrent, etc. So finally, moving on to the issue of protection, it's crucial that decision makers assess whether the protection is not just generally sufficient, but that it will address the risk of the particular kind of harm feared, whether that's exposure to a disaster or detention due to political challenging views around climate change, for example. So the particular kind of harm, the particular kind of protection that's required may include not only national protection mechanisms that mitigate the risk of harm from human actors, and here we're used to dealing with protection as the role of the police, the judiciary, and so on in order to prevent persecution, but also, particularly in relation to scenario 5, we need to think about disaster risk management, climate change adaptation, and sustainable development mechanisms for addressing disaster risk, also as potential protection mechanisms that need to be considered in relation to whether there is a sufficiency of protection in the particular case. Conversely, though, disaster-related risks of harm and the availability of protection should be routinely considered when you're evaluating whether an internal relocation alternative exists elsewhere in the country. And that's regardless of whether the risk in the home area was based on disaster conditions or not. If you can move on to the next slide, please. So I'd like to end by briefly addressing other frameworks for international protection. It's already well established that complementary international protection can take place under the non-refoulement provisions of human rights law, including those codified under subsidiary protection provisions of national law in certain African countries, or, for example, under the EU Qualification Directive. Crucially, most of the rights underpinning these non-refoulement rules can be violated not only by harms that emanate from human sources, but also by those that come from natural sources too, natural hazards, for example. In this regard, the RLI Declaration makes it clear that the interpretative approach to questions such as the severity of the harm, the real risk of occurrence, and the nature of protection are likely to be highly similar, if not identical, to those that I've just spelt out in relation to the Refugee Convention. There are, though, certain differences and complexities when we start thinking about non-refoulement under human rights law. For example, in Europe, the European Court of Human Rights jurisprudence has held that where the predominant cause of harm is poverty or, quotes, the state's lack of resources to deal with a naturally occurring phenomenon, then a higher severity threshold of, quote, very exceptional circumstances applies than when those risks result from the direct or indirect actions of human state or non-state actors. In other words, what the court's saying is that where the predominant cause of a harm is a natural hazard, then you have a higher threshold that's required in order to show risk, and that is very exceptional circumstances. As yet, the European Court hasn't applied this higher threshold to any case involving refoulement to a country where disasters play into conditions of risk on the ground, as compared with the frequent application of this threshold to a line of cases involving challenges to removal on medical grounds. And this fact may recognise the distinct nature of disaster contexts in which the risks of harm are so often shaped by human elements. Moreover, human rights treaty bodies in other regions, including Africa, do not seem to follow this European approach. But if it were applied to disaster cases, it would raise questions about what very exceptional circumstances would look like in the disaster context. Finally, a broader approach may be possible under regional refugee frameworks in Africa, such as the OAU African Convention relating to refugees. These broader regional frameworks extend refugee status to people who are fleeing serious disturbances of public order. And there's little doubt that disasters can contribute to creating or exacerbating such disturbances, and that serious disturbances of public order often occur in situations where disasters interact with or exacerbate or trigger armed conflict and generalized violence. But it's important to remember that individual applicants will also have to demonstrate a risk of serious harm as a result of these circumstances in order to qualify as refugees under the expanded refugee definition in the African Refugee Convention. Last slide, please. So I hope this gives a good overview of the key principles and norms identified by the new RLI Declaration. The challenge is that the factual context of disasters and climate change is one of particular complexity. Nonetheless, the key point is that the essential legal rules governing international protection remain unchanged. All that's needed is clarity on how they apply in this new factual context. I trust that the presentation has given you a flavour of how RLI experts believe this plays out. I really look forward to your questions, particularly around how these rules are to be applied in the African context. Thank you very much for your attention, and I look forward to any questions that you may wish to raise.
Thank you so much, David. That was a really great overview of the Declaration and how it intersects with existing refugee law. As we wait for people to drop any questions that you may have for David in the chat, I will use moderator's privilege and ask one or two to get started. And then you can also raise your hand and I can call on you. So I see Beth Ferris, actually. I'll turn it over to you if you want to ask the first question.
Thanks a lot, David. As always, you're so clear in the way you present the issues, and I think you really have such a wonderful way of conceptualizing issues and making it straightforward. My question is about research. You know, this whole question of the relationship between climate change and conflict has been, there's some really good qualitative case studies. Quantitative studies don't tell us very much. I wonder if you have suggestions for any research that could be helpful in making it clear to policymakers and also to ordinary people the way in which conflict can affect the protection risks, or climate change can affect the protection risks faced by people in conflict situations.
Many thanks, Beth. Jocelyn, would you like me to go ahead or?
Yeah, why don't you go ahead?
Thanks, Beth. It's a really good question. I mean, when we're thinking about the kinds of evidence that is needed in the context of an asylum claim, clearly there's a good mass of material out there on many countries about how disasters create risks and so on. And I think part of the job of research is bringing that attention, bring attention to that body of evidence much more to the fore. However, there are certainly questions about causality that researchers may wish to contribute to. And the RLI Declaration itself draws very much on a wide body of research, which really thinks through very carefully about how the risk of harm emerges in these disaster-based contexts, and therefore what that means for protection. But certainly, I think there's much more scope for research around how those risks of harm are produced, how states react to them, how they construct those risks of harm in some ways, and how societies more broadly work through issues of discrimination in disaster-related contexts. So I think that there are certainly a number of areas of research there which would prove extremely useful, particularly in the asylum-related context. I'm aware also that in asylum claims in many countries, excuse me, there's a big role for expert witness evidence. And I just wonder, as claims based on these sorts of scenarios become more common, whether we need to start thinking about reaching out to a much broader group of experts who are able to comment not just about, discrimination and its effects in relation to, sort of civil and political rights, if you like, patterns of access to social goods and so on, but also about the ways in which, discrimination in any society can expose people to additional risks linked to hazards and the disaster context specifically.
Thanks, David. And I have a related question actually on this, which is around if you think we'll see a greater shift to prima facie status determination, building on your last point around situations of general violence or disorder, that's often used in the African context to do group determination. And we see in a lot of countries years and years that people are waiting for refugee status determination to be done. And so as we're looking at adding additional factors into that determination process that might need more evidence, but also that might apply to large areas, where the area is being affected equally by a disaster, even if people within that area might be affected differentially, how you see that changing the refugee status determination process in various contexts in Africa.
That's another really great question, Jocelyn. Thanks so much. Look, I think there are a couple of points to take here. The first of those is, it's fairly unlikely, I would have thought, that a disaster, well, I mean, one can think of exceptions, but I suspect that most disasters are not going to provide a generalized basis for recognition as refugees under the 51 Convention, because you need to show that really strong pattern of discrimination in order for the exposure to the disaster to be persecution. So, at the very least, or I suppose at the highest, what you may have is, prima facie in relation to, as you say, a particularly marginalized group, which has just been, really badly hit by a particular disaster. And, that may well, prima facie may well play a role there. So under the convention, I think, there is some scope for prima facie, but I suspect it's likely to be, much more on an individual case and picking apart, is the element of discrimination there? Are the risks, well-founded? Are the risks, on grounds recognised by the convention and so on? It's quite a complex matrix of facts that need to be established. Having said that, you also asked about whether under the broader regional definitions like the OAU Refugee Convention, there may be a role there equally for prima facie recognition. And Tamara Wood has published some really interesting work on this in relation to the OAU Refugee Convention, where in relation to Somalia, you have a neighbouring country, Kenya, I think it was, applying the broadened definition on the basis of circumstances seriously disturbing public order. I think I accurately summarised Tamara's work there. But the matrix of facts is not just a disaster, it's the intersection between conflicts, drought, and then the broader kind of deprivation that exists in that context, which constitutes the circumstances seriously disturbing public order. I'm not as yet aware of any scenario in the African context where the OAU broader definition has been applied on the basis of a disaster without there also being very serious dynamics of violence intersecting with that. In the Latin American context, where you also have a broadened similar regional refugee definition, I think it's an even more difficult ask. The predominant view amongst Latin American states traditionally has been that expanded refugee definition in the Cartagena Declaration doesn't apply in the context of disasters. Having said that, I think, again, if you had a situation like Haiti, where you've got kind of a disaster that cascades into all sorts of gender-based discrimination and violence and so on, that there might well be a case for arguing for application there. But I think, on its own, a disaster probably isn't enough to trigger application of that. So, thinking through those kinds of issues gives us a sense of where refugee law ends up on this. And implicit perhaps in your question is, do we need a broader set of tools around this? And I'll leave that question in the air for others if they want to take the point. In the meantime, I'm just going to have a quick look at some of the questions.
Yeah, I can read one out. So we've got one from someone who's working with the Ethiopian Human Rights Commission, and their question is on what role can national human rights institutions play, or what role will they play in ensuring protection of disaster-affected or climate change-induced refugees? And then follow-up question to that, how do we establish the rights of refugees vis-a-vis state responsibility?
Yeah, many thanks for the question. I mean, it's a good one. Look, I think national human rights institutions have a major role clearly in the protection space. And Engede, I'm aware of the work that you do with refugees in Ethiopia. And some of that work is where refugees are living in spots which are disaster prone. Clearly a Human Rights Commission has a duty to be engaging with the disaster response apparatus of the government, or locally amongst civil society, in order to mitigate risks related to the disaster insofar as they're likely to impact on refugees who are living in that country. More broadly, on the point of what role an NHRI like yours might play in relation to people who are leaving a country, I think it's very much trying to push forward, if you like, the message in the RLI declaration, which is to say to your government that we're not saying that every single person who leaves their country because of a disaster is a refugee, but there are a range of scenarios within the disaster context which might well pose risks of harm that constitute a ground for refugee status. In other ways, where somebody arrives saying, oh, I fled the drought in Somalia, don't just stop there. Okay, why did you flee the drought in Somalia? Well, I'm a member of a minority clan. and as a minority clan, I also face discrimination in all of these other areas. So I think it's really pushing governments, decision makers, and indeed lawyers within your constituencies to be aware of the ways in which disasters can play into international protection claims, and just to be live to those possibilities and think constructively about the ways in which international protection law can offer protection to those who meet the thresholds for it under refugee law or human rights law. So I think, broadly that answers that question. But, the flip side of that is to say, well, not all people who leave a country due to a disaster, even if they've got good reasons for doing so, will receive international protection. Not everybody will meet that threshold for international protection. I think it raises, if you like, both a philosophical and a policy question about whether or not international protection is the right way always to deal with these sorts of issues. In my work in the Americas, and I suspect it's not dissimilar in some of the distinct regions of Africa, we've seen that states instead have tended to take a much broader view when they're applying their migration-related tools and saying, look, we're prepared to flexibly apply categories like work categories or family categories because we recognize the humanitarian imperatives of a disaster. But that doesn't mean that we think everybody has a right to admission simply because they're exposed to a disaster in their country. So I think, there's a question, as I say, a philosophical and policy one, about where that line is drawn. And I think, if you look at the work that's been done in the Americas, there's some really interesting points that you can take from that to think about, where do we do all of the work here? The other thing that I was just saying, Gaudet, in relation to your question is that, we need to be a bit careful, I think, about assuming that refugee law is the panacea to all of the problems in the world. It's not, okay? And it's not intended to be either. Actually, the major way of dealing with the risks that are posed by disasters, by climate change, is through disaster management and response. It's through climate change mitigation and so on. And of course, the vast majority of people who move in the context of disasters and climate change don't leave their countries. And so, thinking about mobility in that context, how internal displacement frameworks or internal migration frameworks work in order to allow those people to exercise their rights in their own country where they may want to stay, is, I think, our first point of reference. And really the proportion of people who do leave and will leave their own countries owing to these sorts of processes is the tip of the iceberg. And again, even the tip of the iceberg, I think the vast majority of them will move under normal migration routes, and whether directly under migration routes. In other words, often following a disaster, we see normal migration options increasing dramatically from people who are from that country. In other words, people are affected by the disaster, but rather than applying for asylum, they go and work in another country, right? So even the tip of the iceberg, the vast majority of the response, I think, is migration related rather than international protection related. Having said that, there are going to be some cases where those migration options are not available and the risks are so severe that we do need to put international protection mechanisms into play, like refugee law. And that's really what the RLI, that very, very narrow point and the very, very tip of the iceberg, is really what the RLI Declaration is all about.
That's great. Thank you for that. And I think that intersects well with another question we had around statelessness. And I'm curious if the team that developed the declaration considered sort of how it would intersect with issues of statelessness. The question is in the Rohingya context, but also there's a lot of existing work I know in the African context as to how climate disasters and environmentally driven disasters might be affecting stateless people and what maybe additional rights they may have in these contexts or protection concerns that we should be aware of for them.
Yeah, I mean, there's been a long-standing debate around whether, for example, the disappearance of a Pacific Island nation may be a cause of statelessness, and therefore whether those people, once they're outside that territory and living in a country which is not their own, are in fact stateless persons and require protection under the statelessness conventions. Having said that, my understanding of the debates that are going on, at least in the Pacific at the moment, are that most of the people who are in fact members of those nations are not particularly keen on that idea. and that really they would much rather remain a nation and much rather that the effort is put into ensuring that they can stay in place. In other words, taking climate change mitigation measures, dealing, reinforcing disaster response and so on. So I think, one has to be a little bit careful there about that issue. Of course, stateless persons may also face persecution in the same way as others. They can also face, human rights violations, and in that sense, the Refugee Convention's very clear that stateless persons can qualify for refugee status if they have a well-founded fear of persecution and so on in the countries of habitual residence.
Great. Thank you so much. And then we have two sort of related questions around what resources or programs are available to help build legal expertise in refugee law within refugee communities to support their self-advocacy. So how can refugee-led organizations learn more about international refugee law to advocate for their rights and protections in the international arena, and any resources that you can share for refugee-led organizations in that regard?
So I suppose the first thing to say is, UNHCR has a vast range of kind of advocacy tools that can be found freely online. From the university side, for those who are interested, the Refugee Law Initiative has on Coursera a course called Refugees in the 21st Century. And if you're interested in learning more broadly about the refugee issue, about what refugee law is and how it applies, it's a 6-week course, and it's open for free. If you want a certificate, you have to pay a small amount, but all of the learning is there and accessible for free. So that may be something that's of interest. We also have a similar course on Coursera called Internal Displacement and Protection, and that deals with some of these kinds of issues in the internal displacement context too. One question which I think came up tangentially, though, is about climate change. And I think, it's worth perhaps just reiterating the climate change point here. In previous discussions, and particularly with colleagues in the African context, one of the questions has always been, but, doesn't climate change make you a refugee? And I think, legally it's a difficult position to argue. And what I'd like to leave you with as a thought is, if you think about, let's say, persecution in a particular country, then persecution is the thing that the Refugee Convention protects you from. Yeah, it's like, if you like, the closest, the most proximate, the most direct form of harm. And that's what refugee law is concerned about. But behind that dynamic of persecution in a particular society, there may be bigger global factors. There may be factors like, increasing globalization as, a driver of those kinds of conflicts, or, increasing nationalism, right? But refugee law doesn't deal with those kind of broader global trends. And I think if we're thinking about disasters, that's a good analogy, in the sense that the hazard, the disaster, is the thing that poses the risk of harm to you directly. And it may be shaped by broader global processes, including globalization, but also climate change, right? So climate change sits, if you like, in the backdrop, shaping things. But in and of itself, it doesn't constitute a context which we see as producing a risk of harm in the way that, for example, a disaster might do, or, an armed conflict or political violence towards, opponents of the regime or whatever. So I think it is just worth ending with that idea that, we talk a lot about climate refugees. We talk about the influence of climate, and, that's all right. Climate does play a role in shaping mobility in all sorts of different ways. Some of those are very negative. Some are very positive. The increasing warming of the northern poles may make them more habitable. People may voluntarily migrate there, for example, right? I don't want to be, I'm not a climate change denier by any stretch of the imagination. I don't think, there are going to be many positives, but, the impacts of climate change are very complex in the way that, across the world in different regions and different contexts, they help to shape how people take decisions about how to move. And that's fine. But when you come down to this level of, hi, somebody's arrived in a country, the government of that country is taking a decision about whether they merit international protection, whether under refugee law or human rights law, climate change isn't that direct factor. It may come into the kind of the well-founded fear analysis as one of those factors that, over time may produce a well-founded fear. But for the most part, it sort of sits there as a background shaping factor. So I think it might just be worth, ending on that point to make sure there's clarity on it.
Great. Thank you so much, David. I think this has been a really informative presentation, both on the declaration and then next steps to take that forward. So for those of you interested in more resources, Nick has dropped the declaration text in the chat, as well as the links to 2 Coursera courses that are freely available for you to take if you're interested in learning more from the Refugee Law Initiative at the University of London. So thank you to David, and thank you to Nick for coordinating this wonderful event, and to the Refugee Law Initiative for really leading all of this work on how we're thinking about climate change and disasters in the context of refugee law. And thank you to all of you for being here today. I believe this will be recorded and made available, so if you'd like to share with colleagues or anyone else, you can follow the Refugee Law Initiative in order to get access to more resources as well as the recording of this. So thank you to David.
Thanks so much, Jocelyn. Thanks, everyone.
Take care, everyone. Have a lovely day. Have a lovely evening.